Bernicia is going to be giving us a very good talk tonight. We've been very, very lucky to get Michael up here. He's sort of royalty in the 3 months over. So to Michael anyway, let me get started. Notepads and pens ahead. There's got a lot of information coming fast.
Just let me know if you can't hear what I'm saying and I'll try and speak up. So, first things first, how many of you in the room have seen me speak before? Okay, how many people in the room are not familiar with freetheplanet.net? Okay, that's my website for those of you who don't know. How many people in the room are not familiar with the remedies that I have obtained with the taxman and the registrar? How many are not familiar? Okay, right. Thank you very much. Now I can just about gauge where to start. So those of you who already know some of this information, please bear with me, because there are some people in the room who are actually there at the very beginning. Where this really began for me was myself and Amit Zala, along with a guy called Tom. We'd all declared that we were no longer going to be governed by Her Majesty's government, and we declared our own sovereignty. And we really took a leap of faith. It was something that we all believed was the right thing to do, and we did it in our own unique ways. And at that time, there was very little information to be gleaned within the United Kingdom, or related, shall I say, to the United Kingdom and Great Britain, and what exactly constituted a freeman and what constituted lawful excuse, and all of the rest of a myriad of terms that were being bandied about by the Canadian freeman movement, which obviously had inspired us to have a look at the law in this jurisdiction to see whether or not we could find remedies for the problems that we were facing every day and the people around us were facing every day, because through our own research we discovered that there was really no such thing as a bank loan or a credit card loan or a mortgage. That all of the evidence suggested that the banks weren't lending any money, but they were acting as if they lent you money and then charging the principal plus interest. Now, at the time, we were just nutters in the corner rambling on about stuff that people weren't really interested in because they thought it couldn't be true. But so we convened a meeting of like-minded souls who all gathered in Derby, and we put together our information, and we found that there was an awful lot more work needed to be done. But one thing was certain: things could not carry on the way they were. And at that time, there was no information out there in this country for anybody who was interested in any aspect of so-called commercial redemption or so-called freemanism, for the want of a better term. And we decided that at the very least, through our own experiences and our own research, we would just put all the information that we believed was valid out there, and whoever was attracted to it would take it and do with it what they wanted to do with it. And if what we were doing was wrong in any way, we would find out why it was wrong, and if it was right, we'd find out why and how it worked. So we got to a point where we realized that within the system there's very little remedy available, and there's very little protection available from the courts and from the police and from the government agencies. And the corporations who seek to take everything from us in every way they can every single day that we walk around in this jurisdiction, and not only are wages and salaries either freezing or being cut, but fuel is going up on an almost daily basis, and it's been like this for a long time, as with the price of food and everything else that we perceive as our basic necessities. So, what's the solution? When you go into the system, when you stand up in the court and you say, I demand justice because this prosecution against me would seem to be in breach of the constitutional law of the United Kingdom. What do you do when you stand up and say that and the judge says, not today, sir. Not in my court. Because this has happened again and again and again when people like us have stood up and said no more fraud, no more deception. If this is the law, the court should apply it. But if you're involved in any issue where there is a crown interest or a bank or a multinational involved, and that's virtually every single issue that ever ends up in court, you lose. You lose. So, at the time when we began on this journey, there was a false perception among researchers in our fields that went something along the lines of, stay away from statutes at all costs, you'll just get into trouble. When actually the opposite was the case. The only way we can obtain any remedy from that system is when we do apply their rules and their statutes against them. Now, as I say, most of the time they just rule against you. But we've gotten to a point, after almost 4 years of constant research and constant striving to achieve and obtain remedies that we could share with everybody, that everybody could apply in their own lives. We've reached a position where not only are the judicial system and the legal professions starting to take notice of the allegations we've been making against the banks, we've also been advised by the Financial Services Authority to go directly to the Ministry of Justice and ask the Ministry of Justice to convene a test case in the High Court to decide whether or not the following allegations are true. Every bank in this country who engages in the mortgage business, every single bank that we are aware of is guilty of, as a matter of corporate policy, breaching the following laws. The Law of Property Miscellaneous Provisions Act, 1989, Section 2. In basic terms, that law prescribes that every single mortgage has to have a mortgage contract that all the terms are expressed within before execution and contained in a single document where contracts are not exchanged, and that document must be signed by both parties, the mortgagee, the bank, and the mortgagor, the alleged borrower. If those things are not true about a mortgage or an alleged mortgage contract, there is no mortgage. The contract is void ab initio. That means from the beginning. There is no enforceable contract, which means there is no enforceable debt. That is true of every single mortgage, I repeat, that does not have a Section 2 compliant contract with the signatures of both parties and all of the terms and conditions contained therein. No mortgage is enforceable. And yet, since we brought these allegations to the courts, probably for the first time in 2009, until now, they've been dismissed as totally without merit in English law. They've imposed civil restraint orders against many of us who brought these allegations, saying that if you bring these allegations again in any court, then literally we will arrest you for contempt of court because there's a civil restraint order in place preventing you from doing that. I had that threat myself in the case that I was involved with. And I just want to tell the story of that case, because that case provides the background to the next phase of the development of the case against the Banksters. Okay, so on February the 19th, 2010, I went as representative of my family's private property trust to its bank, and I presented the bank with a promissory note made payable to bearer to the value of the debt that the bank was claiming the trust owed. The trust had, in good faith that the bank had lent them money, mortgaged its properties, or at least they thought they'd mortgaged their properties, but there was never any valid and enforceable contract that was issued by the bank. But of course, at the time, the trust didn't know this. So, in good faith, they presented the promissory note made payable to bearer, which, as confirmed by Lord Denning in the Court of Appeal in 1969, I believe it was a promissory note or a bill of exchange made payable to bearer is exactly the same as cash. In the HBOS Group Reorganisation Act 2006, in the schedule you will find definitions of the terms contained within this act. And this act prescribes, among many, many other things, that instruments such as promissory notes, whether made payable to bearer or otherwise, and other forms of negotiable securities are accepted upon deposit by the bank, whether to create lines of credit or to extinguish liabilities. It's there in the act which covered the legality of the bank in question's actions. And the bank said they'd never ever heard of this kind of transaction before. That a bank who has an international presence, who has been a bank on these shores for 300 years, who was a national bank, did not know about promissory notes made payable to bearer, and the fact that that bank accepts them on deposit to satisfy liabilities. Well, we said that that constituted prima facie evidence that they were lying. So we sent a whole list of questions to them. We asked for, the notice was a notice requesting adequate assurance of due performance. In this notice we demanded to be presented with evidence that there was an enforceable contract signed by both parties in existence. We wanted evidence of the actual instrument of deposit which created the alleged loan. We wanted them to answer all kinds of questions with regard to the negotiable instrument that we presented, because, as per the terms of the Bills of Exchange Act 1882, Section 43 prescribes that if you tender a negotiable instrument such as a promissory note to someone who claims a debt from you, and if they refuse that debt and you enter into a lawful process as per the terms laid out in that act, the Bills of Exchange Act, you do a notary protest on it, which we did. If you do all that and the bank still refuse to accept the instrument, the debt is discharged. So this is what we notified the bank of. The bank then put in a demand. They ignored everything we said. They refused to answer the questions that we put forward. And so we terminated any existing or previously existing contracts that could be deemed to have been enforced on the basis that the bank had clearly misrepresented the facts. They'd failed in their fiduciary obligation to accept the negotiable instrument in satisfaction of the debt, which meant, in accordance with the laws of banking, as per Paget's laws of banking, when the creditor receives the payment for a debt, the remedy to sue for the recovery of the debt is automatically suspended. This is a maxim of commerce. It means that you can't be sued if you genuinely, in good faith, make an attempt to make payment. But what the banks have done is they've shut us all off from this lawful remedy. Every single one of you should be able to go into a bank tomorrow with a promissory note. We can provide you a template for this, and if it has to be a promissory note made payable to bearer, you should be able to go into that bank, instruct that bank to open what's called a private trust deposit account. You make the deposit in that account, it stays there. The credit is transferred into a public side account which you can access. The credit, once it's gone, is not payable back to the bank. The note is what created that credit, and the note, once the credit is gone, is retired. The difference between a private promissory note made payable to bearer and a promissory note by a banker is that the banker's promissory note can be reissued after payment again and again, whereas the private promissory note must be withdrawn, otherwise it's a fraud. Okay, with all those things borne in mind, the bank immediately said they had no interest in legal proceedings, and having been served a commercial and statutory lien, which is now valued in excess of £200 million, that was served upon the chairman of the bank, and his solicitors reacted very aggressively. They accused us of all kinds of things that weren't true, just trying to obfuscate the issues and to prevent us from moving forward. But inevitably, we ended up filing a claim for fraud, to decide whether or not the bank was guilty of fraud or misrepresentation, and on the basis that there was no enforceable mortgage contract in existence, and even if they could prove that they had lent the trust the money, which again there was no evidence that they had, that debt, if indeed it did exist as a debt, had already been discharged because of the note. But worst case scenario, we said to the bank we'd be prepared at every stage to reissue the payment of the note, and they could accept it at any point. But they refused point blankly again and again. So it gets to the court, and I'm allowed to present a skeleton argument of 19 pages to a High Court judge and a barrister who was acting for the bank and the receiver who was unlawfully appointed, but they had the same defence, and the two lawyers of the bank were sitting behind, and there was a clerk in front of the bench, and that was it. There was nobody else in. It wasn't much different from this room. I kid you not, just the furnishings were different, that's all. It was very much like this. They'd hidden it away. I said everything I needed to say. I made the points. Look, in the evidence file, Your Honour. That's ironic. In the evidence file, there is what is known as a facility offer and acceptance letter issued by the bank. This is the document that they are relying upon as an alleged contract. It only has one signature. That's the signature of the trust. It does not have the signature of the bank. This was the primary focus of the skeleton argument, and of course I also talked a lot about the law of negotiable instruments in relation to the tender of the promissory note, and that really, rebutting that, is what the barrister focused on. He glibly passed over the unsigned contract, saying the bank did not need to sign the contract for it to be enforceable. The judge agreed with the barrister, and then inexplicably said, after retiring for around about 15 minutes to write his 25-minute judgment, he came back and ruled that the contract was signed by both parties, and on that foundation alone, he based the rest of his judgment dismissing the claim as totally without merit and awarding costs to the defendant. Immediately, I said to him, Your Honour, you've made a mistake, and he told me to shut up. I'd had my opportunity to speak, and I wouldn't get another one. If I wanted to raise any more points, it would have to be on appeal. So I said, Your Honour, may I have permission to appeal? On what basis are you applying for permission to appeal, he said. So I said, well, with all due respect, Your Honour, on the basis that you have erred in law today. Permission denied! On the basis that you've got no reasonable chance of success. And that's the last I'll hear of it. Your only available option is to the Court of Appeal. We put in, within 28 days, a Court of Appeal application for permission. And this appeal contained all of the case law that we didn't have at the time we filed the claim in support of every allegation we made, including the statute that I've already told you about, the Law of Property Miscellaneous Provisions Act 1989. We knew nothing about that statute prescribing exactly what we believed was the law of mortgages, and the allegations that we made were now backed up with statutes and case law. We put in the application for permission to appeal on the basis that the appeal should have been granted. Permission should not have even needed to be sought, because the bank didn't sign the contract which was in the court file, and the judge made the mistake that they did. Well, whether it was a deliberate mistake or an accidental mistake, he still made a mistake, which caused him to err in law, or at least that's the most honourable explanation that is available to him. Because otherwise, we can only allege corruption against him, that he knew exactly what he was doing, and he did it, he planned to do it this way. The judgment was already written before we presented the case. But that's by the by. The Court of Appeal took 12 weeks in an application process which is supposed to take, I think you're supposed to get something back within 14 to 21 days, but it was, what did I just say it was? 12 weeks, that's it. 12 weeks. And when it came back, they left a very interesting piece of information on one of the files that we filed in support of the application. There were two big bundles that I sent in. And one of them had a card that was sellotaped on the corner, and it had the initials of two Lord Justices. One whose name I temporarily forget, but he was the initial justice in charge of the application. It was then passed on to Lord Justice Lloyd, who was already being tipped to be potentially one of the next, well, if not the next Master of the Rolls, then the Master of the Rolls after that. He's supposed to be one of the Queen's favourites, and accordingly he looked at the application and he decided that it was completely without merit. He backed the judge 100%. He echoed every single point that the judge made, and he threatened me with a civil restraint order. So, undaunted by that, within a couple of months of that, we made another application for permission to appeal to the Supreme Court. This time, urging them to take jurisdiction in the name of truth and justice, because this case, we'd since found out, since the very beginning, since its inception, that this case is representative of millions of so-called mortgage holders in this country, and that the Supreme Court had the jurisdiction to intervene. Because it can make up the rules as it goes along if that action is in the name of truth and justice, as it should be. And the Registrar of the Supreme Court, who is also the Registrar of the Queen's Privy Council, decided that she was not willing to present the application before any of the law lords on the basis that the Supreme Court did not have the jurisdiction to challenge the decision of Lord Justice Lloyd. We weren't challenging the decision of Lord Justice Lloyd. We were challenging the validity of the original order. If the original order was struck out as void, as it should be, every order that follows is naturally void. So it's as if the decision of Lord Justice Lloyd to refuse permission to appeal didn't happen if the original order is struck out. So I represented the application to the Registrar of the Supreme Court, and I sent more case law and more statutes in support of what we were putting forward. And this time the application wasn't returned, it was shredded, and she basically said she did not care what points we made, that the Supreme Court was refusing to take jurisdiction and I shouldn't send her anything else. I told her in my final letter that we would regard such a refusal as a miscarriage of justice and a breach of constitutional law, in that justice and the right to justice was clearly being denied to the claimant. So, at this point, we organise ourselves into a group which has very fondly been dubbed the Banksters. We're everywhere, right across the country now. We're gathering together mortgagors from all of the banks, because what we've done is file a representative complaint, firstly against the Bank of Scotland and the Lloyds Group, alleging that they're in breach of multiple statutes, and as such every single court order that's been issued in thousands of possession hearings up and down the country for decades, every single one of those is void if this claim is upheld. When we spoke to the FSA, the Financial Services Authority, about these points, having read the complaint, as I say, the FSA suggested that we take it directly to the Ministry of Justice. But we don't need to do that, because the position we're in now is complaints over the next few months will be filed with the Financial Ombudsman Service against every complaint that we filed with the FOS against the Bank of Scotland. At the same time, the order of the High Court that I've just told you about in my case 2 weeks ago, I applied to have it struck out as being a void order on the basis that it lacks due process of law following the fatal error of the judge not to inspect the evidence correctly. If this order is granted, the entire victory of the bank in that case is wiped out, and the claim of the claimant, which is our claim, will be reinstated, which would mean the following. First of all, the receiver's appointment would be struck out as unlawful. The bank would be declared that the bank did not have a legal mortgage upon which to rely on, and that all of the mortgages that allegedly exist have to be removed from the land registry, which would mean the trust is free and clear of all encumbrances, and that a trial by jury would be listed to hear whether or not the bank is guilty of A, gross negligence, B, misrepresentation, or C, fraud. And if fraud is proven in a civil court, a criminal complaint of fraud will then be made. And this is going to happen against every one of the mortgage companies currently doing business in this country, because if that trial is listed, it will become a representative action, because the points are exactly the same against every bank. Now, let's just say that that didn't happen. Let's just say that they uphold these miscarriages of justice that are resulting in people being thrown from their homes without any lawful cause. We already have international arbitration proceedings that have been convened. They are suspended, but pending the outcome of the FOS complaint and any action that takes place within the courts of their judicial system. Now, let me also say, if the bank is able to demonstrate that it actually did lend its own money in any of these cases, then we accept that it's our liability to repay that debt. But if the bank, let's just put this into perspective. The fractional reserve system means that every bank, upon the deposit of £10, can lend at least £100. So everyone understands that, yeah? So it's actually much more than that now, but that's the basic premise of it. Therefore, if every bank that lends in the mortgage industry can lend much more than it actually has on deposit, and the definition of a loan of money is that money has to be in the possession of the lender for the loan to be valid. So if the money isn't in possession and they're just actually lending money they don't have, money on credit, imaginary money that they just create with a flick of their finger, well, that's not a loan of money. Because we did a lot of digging on this. We looked at the terms in the mortgage deeds, or the alleged mortgage deeds, and the alleged mortgage contract terms and conditions. Most of the banks issue them by just sending them to the land registry and declaring that these terms and conditions apply to all their mortgages without actually disclosing those terms in advance of the execution of the contract by the mortgagor. So, let's just clarify things. The critical element in every single mortgage document is a power of attorney clause, which is granted to every single mortgage, is granted by every mortgagor to the bank. And this allows the bank to issue, create, and use in your name, to its own benefit, any document, deed, or instrument it deems fit and appropriate to secure its own secured interests under the mortgage documents. I'll just repeat that in more simplistic terms. The bank has the lawful, or rather the legal authority under this unconscionable term, which means it cannot be justified in a court of law or equity. Nevertheless, this power of attorney clause allows them to create a promissory note made payable to bearer or otherwise in your name and deposit it in their account, and then pretend that they're lending you their money when they've actually stolen the full payment from you, and then they claim that they're lending you their money at interest over 25 years. So they've been paid with your money that you created in your name, only you have no knowledge of that, and then they pretend that they've lent you that money. Now, how do they get away with it? Because The conveyancing solicitor is in control. The conveyancing solicitor never says anything but a credit going to the account. He assumes the money is being transferred. That's why the account's being credited, the escrow account. And therefore the completion of whatever the sale of the property is, it can go through. However, look at it this way. Mortgages, the vast majority of the time in this country and everywhere else, are executed by the mortgagor, the alleged borrower, before they actually own the property being mortgaged. They don't get the money first to buy the property. They get the money after they've signed a deed conveying that which they do not own to the bank. The effect of that is to render the entire mortgage null and void, but not at the liability of the mortgagor who signed that document in good faith. They were deceived into it. The bank simply doesn't have a defence to say that they didn't know this was going on. Not only did the bank know that this was going on, we now have first-hand evidence from somebody who used to work for Kensington Mortgages. Kensington Mortgages was, until very recently, owned by a company controlled and owned by Goldman Sachs. Now, this is what was going on. Every so often, every month or 6 weeks, a guy would come into the office where everyone worked in an open plan office except the boss, who was separate in his own office, and had meetings with various people who they recognised and some who they didn't. But every few weeks this guy would come into the office and he was known as the forger. He would forge the signatures of the mortgagors on the mortgage documents. And this would be done openly, and literally they'd all be acting like it was perfectly normal, or it can't be against the law, otherwise we would never get away with it as a company, you know. And they used to joke about it, what a good forger he was. Did you used to forge your parents' signatures on sick notes when you were in school? These kind of questions. Well, yes he did. And now he was doing it for the mortgage company. This is standard practice. How do we know? How do we know this isn't just a one-off? Because in America, there are federal prosecutions now going on that have been going on for the best part of the last 2 years against banks, including Bank of America, Barclays, HSBC, for having hothouses of forgers sitting there forging directors of banks' signatures on mortgage documents and mortgagors' signatures. Both. They're being prosecuted for it. Bank of America were ordered to pay compensation, and after an audit of their finances, declared finances, it was deemed by the judge that they should pay a little over $3,000 to every injured mortgagor, most of whom had had everything taken from them. When a bank can create a credit with the flick of a pen, with the flick of a switch, as can we, but they don't let us. So again, not relying on just research and other people's research and opinions and discussions, we looked at the hard evidence, we looked at the law, we looked at the case law, and then we went to the banks to see if it was true. I somehow managed to end up in a conversation with a private banker at HSBC. I put the following proposition to the private banker. So we've created, for purely humanitarian and environmental purposes, not for profit, an international trust entity which is looking to make deposits with certain negotiable instruments in private trust accounts in order to create the necessary lines of credit to acquire land and infrastructure for new communities that we're going to build right across the planet. And he said, this is on the phone, what kind of negotiable instruments? So I said, promissory notes made payable to bearer, usually, but also other types of bills of exchange. And he said, I can't see any problem with that. So I asked him to put it all down in an email, and he did. It was all confirmed again. We got to a point where documents were being exchanged, and then something in my heart it stopped me creating the energy necessary to take it forward. Because at the same time, we created something called the Universal Community of Self-Realization in order to form a template that can be applied to any community right across the planet, right across the universe, anywhere, and to re-establish natural law on Earth for the benefit of mankind without exclusion, in harmony with the planet, instead of exploiting it for private gain. We created this entity, and we had an arrangement in principle with this bank, and we also had knowledge that the same bank, HSBC, has a program, or did have a program, called the Private Placement Program. Private Placement Program, it allows high net worth individuals to make deposits in high interest accounts, which they blow other high interest accounts out of the water. It's totally not for profit except for the bank. The bank will take 20% of what gets made. But if, let's say, an investment of 1 million is held in an account in this program for 40 weeks, it will make 1 million. If it's AAA rated assets, it will make 1 million every week for 40 weeks. So 1 million will make 40 million, and 40% goes back to the investor, 40% goes to the project. It's tax free, and the bank takes 20% off the top. We just didn't want to do it. And we knew that if we put the energy out there, if we were putting the right energy out there, then we would be able to create something which we have called a permanent credit facility. A permanent credit facility is exactly that ability that we should have, but the banks don't allow us to have, because they put a limit up. Nobody can make the kind of deposits I'm talking about. Nobody can even get in with a private banker to have this conversation unless they can prove at least 2 million in net fixed assets. It's exclusive for the rich, like everything else that is allegedly worth having. However, in a permanent credit facility, every single family has a means to go and make their own deposits with notes they create themselves. They create the line of credit to extinguish their debts, to acquire whatever they need for their family, to rid themselves of the debt slavery, to rid themselves of this requirement to go and do 40 to 80 hours a week, doing something that makes their heart cry just for the money, just to get by, just to scrape an existence, and end all that for everybody. Otherwise, it's just bullshit. Because that's the way it should be. We're the only species on this planet that has to pay for our existence on it. We've got supposed dominion over the earth, where it's only slaves. And we've made it this way because we've allowed other people to take control, and we believed everything we were programmed to believe up to a certain point. Because we all knew, really, deep down in our hearts, something was wrong. And the only way all of this changes is if we decide in the bottom of our heart that we are just going to do the best we can do in every moment, no matter what. And to know that the solution does not ever involve violence. Even though we all have the unalienable right to self-defense. We have to do this peacefully. And the best way to do it, as far as we can see, because we've gone into the system and we've tried to obtain justice and fairness for people, as opposed to corporations and the moneyed aristocracy. And in the main, it hasn't been possible, despite the victories we might have had. It doesn't matter, because for most people, they're just slamming the door in their faces. They're not getting any remedy at all. So we realise that even if we still have to go and shine a light on that system to allow people to know exactly what is wrong and what needs to change and the reason why we need something new. Because the system, when you're right inside it, when you're standing in a so-called court of law, and you're encircled by a group of people who all have different roles in a court. They all are supposed to be working for somebody else, but they all represent a different tentacle of the crown, which is really the banksters in disguise. And when you're standing there and you've presented the facts and you've had the judge agree with you, yes, the points of law that you're putting forward are quite correct, it's just I'm not going to apply them today. And then when you stand there and you tell them, with all due respect, Your Honour, this is a misapplication of the law, and you reel out statute after constitutional convention at the judge, and the judge dismisses it, and then suddenly you feel the venom in his words and in his heart as he finally reveals himself, and you feel like a fox that is surrounded by hounds, that is just about to be devoured and ripped apart and have its tail torn off and the blood smeared on a child's face. That's how you feel, surrounded by those people, if you're on your own. So we wanted to make sure that no one had to go and do that shit on their own anymore. And that's when there are so many people like us all over the country and all over the world who are organising groups on Skype, groups that meet like this. There is a way through this mess. You just can't go around it. You have to stand up to it. You have to say no more bullshit. You have to say no to the fraud. You have to say no to coercion. And you have to say no to that nagging doubt that you have in the back of your head until you silence it, that says, if you don't do what you're told, everything will turn to shit. You have to let go of the fear. Because when you do, everything crystallizes. Everything. When I used to lie under my duvet, I tell this story quite regularly because I think it's quite effective. When I used to lie under my duvet, crapping myself about the brown envelopes that were going to land on the mat, I got shitloads of brown envelopes to deal with. When I used to lie in bed saying, but if I do that, what will the Crown do? What if they say you can't do this? And if you continue to say you can, we're going to lock you up. Well, that's what they said. I had 7 Crown agencies at the same time, all tax officers coming at me saying, if you don't pay the aggregate of £67,000 within the next 7 days, that's it, you're going to prison, son. We've had enough of you uppity Geordie. And then I revoked my consent to be governed. And I stood up to them, and I expressed who I was, as a unique fragment of divine consciousness, and I didn't accept their authority to govern me anymore. And it wasn't that I was saying I was better than anybody else. I was saying that nobody was worse than me. And they didn't like that. Because that meant that they couldn't claim any authority over me either. And I also declared my intention to create the universal community of self-realization, and to view my community as mankind on planet Earth. And this was declared to the Queen. The Queen has acquiesced to all of the terms within it. It has created what is known as an implied treaty in international law. As I declared my intent, I declared my unalienable sovereignty as granted by the causation of all that is. And that's a very difficult one to disprove, even for the Queen and her minions. Nevertheless, what has transpired over the course of time is something quite remarkable. Not only has the idea of living in harmony within a community under mutually beneficial cooperative trade agreements, in which everybody in a community pledges to their community whatever it is they do from their heart for the benefit of mankind and their community and their family, whatever it is, that's what they pledge to give away for free in return for everything that the community produces for free. Of course, until such time that we can do without needing to do any business with that system, you can still carry on having whatever identity you have in that system and become a beneficiary of the trust, until such time that you get to a point where you can say, well, I've relinquished all responsibilities with that society now, through your own choice, and you've consented to the jurisdiction of the UCT under natural law, and you've formed your own community. Well, as we all know, that's dependent on being able to extinguish all those liabilities that are following you around, and being able to acquire the land back when it's been stolen from us, under the claim of William the Bastard, who wrote it all down in the Doomsday Book after 1066, and this is the full extent of the claim that the Crown has against the people now. It's no better than that. No one's challenged it, because people were so oppressed through certain centuries, and people were so ignorant through other centuries that they didn't know they could. Because we've been robbed of our history right across this planet, of what really happened, in order to confuse us about where we are in space and time. Because just look at it this way, if I didn't know where I was in space and time at 35 minutes past 2 today, when I pointed the car, I wouldn't be sitting here now, because I wouldn't have known how to get here. If we don't know where we are in space and time, let's just say that all of the stuff that you might have read or heard about 2012 is really an enormous mind control or flip. what if you found out, or what if you were presented with evidence that the date today is actually more likely to be 40 years from now, 2052? How could that happen? We've had 500 years of the Gregorian calendar, roughly. For the previous 1500, we had the British calendar, which started at 0, the year of Christ's apparent birth. 500 years ago, Gregorian calendar was imposed, and then imposed right across the planet, and they started 0 AD at the 32nd birthday of the Christ figure. 32 years taken away. That means you look back in history, it all goes tits up as soon as you get into that era, into the Gregorian era. Then, you also take this into account. 360 is what, during ancient times, and they weren't the Dark Ages I'm talking about a more enlightened time in the past, but we'll come back to that later. 360 days in a year. So the Gregorian calendar added 5 days each year. If you add up the difference in time, you get 7.9 years. Add that on to 32, and you get 39.9. 40 rounded up. 2052. Take a second to ponder that one. Okay, why would this be so important? Why would it be? Well, it seems that there's evidence. When I say evidence, I'm talking about primary documents, manuscripts, gravestones, tombs, ruins, archaeological sites, and from my own experience, just by the Roman wall, there are rocks which have clearly been vitrified. Vitrification happens at temperatures normally in excess of 10,000 degrees C. Okay? The only known source of those temperatures would be from the sun, or a comet or a meteorite, or nuclear fusion, man-made. 562 AD corresponds with the date of the vitrification of rocks right across these islands. I've got photographs which I don't have the means to show you at the moment, but I may do in the second half after we have a break. But I've taken photographs of these rocks. They're all on freetheplanet.net. You can see everything that I'm talking about at that website. However, these rocks have been melted together, and you can see them. There are limestone rocks, huge slabs of limestone that show the signs of vitrification. You can see joins, but there's no form to the joins, and it looks like, as is the way with limestone, that it's been decaying because of the erosion of the elements. And other rocks that were vitrified, they're still in the same vitrified form. They've got bubbles on them. Right? They're very, very strange colours as well, and they're not affected by the elements. And I've seen these rocks with my own eyes. And there are two researchers called Alan Wilson and Baron Blackett who've been writing about this subject and other related subjects for the best part of the last 3 decades. And I would highly recommend taking a look. And there's also an ancient history and cosmology section at Free the Planet. Now the reason I'm telling you this is because the nation that lived here in 562 AD, when it seems that the comet struck Britain and then struck Bolivia after Britain, creating a barren wasteland on the most bountiful islands in the Northern Hemisphere and the most advanced culture in the Northern Hemisphere, on the basis that they were famous throughout the world for 3 things. For having fearsome warriors who had no fear of death. That's because their divinity was bred into them. And there was a system of law that had actually been codified. Was talked about by one of the kings, King Hywel, one of the Welsh kings. This system of laws is far more advanced. There are some things that wouldn't apply, but it's far more advanced than anything that's any form of law that's been codified over the past 150, 200 years, if not longer. Every single man for his family was entitled to 5 acres of land, according to those laws. Water, fish, animals, they were all for the use of the people free of charge. Rocks, unused rocks could be used to build. Everybody had the right, every family had the right to 5 acres. There was no serfdom. It was the last free nation in the Northern Hemisphere left. It was the only one that wasn't subjugated by Rome. But we've been led to believe the opposite is true. That the ancient technologies were brought here by the Romans. They weren't. They were destroyed by the comet. As were a population that was estimated in evidence that exists in other parts of the world, not just here in Wales. But the population was estimated to be 10 million when the comet struck. There have been 3 Caesars who failed to conquer the British Isles, what was known as Britain. And the 2 islands were Albion and the original name of island, Escocia. Escocia, I think I've got that right. And these 2 islands were known as Britain. And the first British king was around about 500 BC. The first British king, and again, this is all provable, was Brutus. Brutus founded Britain as a kingdom. But this kingdom developed these ancient laws, which meant that everybody was free. That there were 3 sovereigns recognized in law. Everyone was sovereign because they were divine. That was their birthright. But there were 3 sovereigns recognized to act for the people in law. The head of a clan, the king of a region, and the sovereign paramount, who normally became a military dictator in times of war or when invaders. There was a period of almost 40 solid consecutive years when 3 Roman emperors attempted to conquer Britain when they had nothing else left to conquer in the Northern Hemisphere. It was Julius Caesar, Caesar Augustus, and Caligula. And they all came here to do it, and all of them got sent back. Caesar wrote in his own memoirs, Julius Caesar wrote in his own memoirs, that when they came, the second time, they were repelled with such force by such inferior numbers than they were, and suffered such dramatic casualties that they had to call for reinforcements. And when the reinforcements arrived in the form of ships full of legionnaires, the legionnaires had already had word from their comrades who had fallen or almost fallen on the beaches and said that there was something just unbeatable about the ancient Britons, and they refused to get off the ships on pain of death when they got back to Rome. Julius Caesar had mercy on them because he understood why they were doing this. Now, let's just take all of those things into account. And let's just also take into account the fact that following the failure of the Roman Empire to conquer these shores, there were around about 400 years of relative peace when those laws continued to be codified and the culture continued to be developed. And the divinity was known to be inherent to mankind. People knew that they had nothing to fear, and that man was born free, and that man includes women because man was born of woman. And that the original trust in this material existence had to have been between consciousness, the masculine energy, which was given to creation, the feminine energy. That was the original trust. Universal community trust. Universal means of the universe. Community means common unity. Trust, that which no relationship can function without. It can dysfunction without trust, but it can't function. What I'm trying to express to you is that the universal community trust exists in the jurisdiction of natural law already. It's been established. It's just about to be recognized on an international level with treaties that are about to be signed. At the same time, we've managed, through, call it what you will, synchronicity is the best word, I think, we've managed to ascertain that rather than having to go through the rigmarole of creating our own infrastructure for the permanent credit facility, somebody on the other side of the world has had exactly the same idea and called it something else. They've called it a private international bank that doesn't engage in usury. Let me just clarify that. They don't loan any money at interest. They don't loan any money full stop. What they do is they accept promissory notes and bills of exchange from the customers who create their own line of credit for whatever purpose. But every customer has to make a pledge to the bank. And that pledge is that they will not do anything that is to the detriment of mankind or the planet with the money, and that whatever deposits they make, they have not been obtained through anything that is detrimental to mankind and the planet. So, the very first family trust is in the process. The very first beneficiary is a family trust. It's my family trust, and it's in the process of drawing its first line of credit with the bank. If this comes to pass, then we'll have a template to apply to every beneficiary within the trust. And every trustee of the UCT is now in a position to create lines or will be very soon in a position, once this credit is facilitated, to start acquiring land and infrastructure right across the planet. Because what we've decided to do, with peace at our hearts at all times, rather than lead or attempt to conjure up some kind of resistance that may well turn into armed resistance or revolution or anything of that nature, we've decided to circumvent the possibility that that might be organised by the secret services or fomented by the usual banking interests who fomented every single revolution since the French Revolution, the House of Rothschild. It's all there for you to look. Don't take my word for any of this. It's all there if you haven't looked already. Everything comes back to the House of Rothschild, no matter what people tell you. But that's a different part of the exposition, as it were. In this situation that we find ourselves in now, we have decided that the best way to get the land back for the people is to reacquire it back. So we're going to buy, with their perfectly acceptable negotiable instruments, all of the land that's available. And we're going to make offers for everything that we think should be available to the people. And then whatever the Crown and the moneyed aristocracy and everybody else who gained land because of the theft of the land from the people in the Doomsday Book and since, we're going to convene a grand jury to decide whether or not the Crown and the monarchy should forfeit all their lands and all of their ill-gotten gains on the basis that they've been in breach of that constitution for a good number of years, as has every single Crown agency. And the Parliament is now null and void as an institution, I have to tell you. Don't think that that means that the European Parliament has any force or effect over here. It doesn't. These are the facts in basic brushstrokes. In 1999, the House of Lords Reform Act, it took away the House of Lords' power of veto. That means that every single act since 1999 is at nullity at law. That means it cannot be enforced except with the consent of the people. So we only have to withdraw that consent. The reason for this is, under the Constitution, and this cannot be changed, it's written by Blackstone in his commentaries on the laws of England, it's written by many other people besides. On the day, the very day, the moment in fact, that Parliament was not two houses, one of which, the House of Lords, could always veto a bill or an act that they believed wasn't to the benefit of the people. That is no longer possible and hasn't been since the House of Lords Act in 1999, which means all of the statutes allegedly giving legal effect to parking banditry of all natures, so that's all the parking bandits out there, the councils and the private companies, all of those statutes that they rely on every time, null and void, cannot be enforced. That's why if you ever have access to a legal database, have a look for one piece of case law establishing the legal right to levy with fines for any purpose whatsoever without the judgment of a court. That's Article 12 of the Bill of Rights. No fines or forfeitures without the order or judgment of a court. I've been into the county court against Nottingham City Council parking bandits. I won, I had it struck out without attending, and I had it struck out because I delivered a skeleton argument to the judge, which he agreed with on every point. And in that, I made it perfectly plain that it was all void ab initio, void from the beginning. Constitutional law breach. But more than that, I was saying to some people outside, this is very important, whatever you receive in law is whatever you accept that you are presented with. It doesn't mean whatever is served, or whatever is dispatched, or whatever is delivered, or whatever is posted, because someone might post you a dog turd. You don't have to accept that. Well, what if you think, as I do, that when you get a parking ticket and the subsequent notice to owner that it's as good as a dog turd and put it in the bin? Didn't receive that. Anyway, it's void ab initio because it's a breach of constitutional law. I can rely on that if it ever goes to court. Well, it very often does. First time it goes to court, it'll be Northampton Court, Bulk Centre, County Court Bulk Centre, more than likely, or another bulk centre. When it does, goes to the bulk centre, it's being dealt with by a computer. On the back, it says, tick a box if you didn't receive the notice to owner. If you didn't receive it, that means if you didn't accept it. All these points have been put to the judge in the county court. He was a district judge. He's got a reputation as being a bit of a scholar. He's written on the law and procedure, and he did not take issue with anything that I'm putting forward to you. None. And he threw out the claim of Nottingham City Council. They did not have a leg to stand on. They were trying to allege that it was contempt of court because it was received. What they really meant to say was, it was delivered. And they couldn't prove that it was delivered with a mail receipt even. If there's no evidence, there has to be a reasonable doubt that they can't possibly win. This is all on Free the Planet. The entire argument that I used, you can get it there. Okay, so the position for most people is not one that can be easily negotiated. Therefore, we've managed to create a system that's at present as simplified as it can be. It's being more simplified as we speak. There are more and more people who are coming forward and offering their help and their support and their services to the Universal Community Trust. However, the one thing that makes it all feasible is that what I'm saying to you comes to pass with regard to the lines of credit. When all of you can set yourselves free from debt slavery, who here wouldn't have a different life? You wouldn't.
Oh yeah, I would, sorry.
So is there anyone in the room whose life wouldn't be different if they didn't have to slave for the dollar? Okay. Now how many people, seriously, even if you did want to have a break because you've had your nose to the grindstone for so long, how many of you have not got something that you'd really like to do with your lives? Not one. I think that applies to everybody. I don't believe anybody came here with nothing to do. I believe that everybody's unique mission is to make a contribution that no one else can at this time. And yet how many people do you know in your lives that are able to do that? Because of the extent of the deception. Okay, how long have I been talking? How long is it? Hour and a quarter. Okay, shall we have a short break? Yeah? Okay, we'll have a 15-minute break and come back. So, I think I want to just, at the beginning of this section, I just want to focus on a couple of the issues. That I said I would be talking about tonight, because I am aware that there are quite a few of you in the room who may not be familiar with what I did with the taxman and what I did with the registrar. So, I think we'll start with we'll start with the registrar. Okay, so I was talking with my wife when we were pregnant with our daughter, and I say we, I know it wasn't actually physically true, but it felt like it, and it still does. But nevertheless, my wife still has one foot in the matrix. She's a teacher in an independent school. She teaches ethics, religious studies and philosophy, and she gets letters from students thanking her for teaching them to think. So she's not giving them anything on the curriculum, she's giving them something which they're not getting very much elsewhere, which is very, very good. I'm sure there are many others out there, so-called fifth columnists, veering off the curriculum and telling people to think for themselves instead of just repeating everything. Anyway, we decided together that on balance, neither of us, no matter, even though I didn't have any anxiety or fear over it, my wife's anxiety and fear over what the so-called authorities might do if we refused to register were completely blown away by our joint goal to make sure that nothing, not one single penny, was going to be spent using her name to finance an illegal war against anybody in any part of the world, or any kind of war. And the reason that we took that position is because there's an act of Parliament called the Government Annuities Act 1929. That's Government Annuities Act 1929. And this act gives a very unusual power to the National Debt Commissioners, who have appointed on their behalf the Comptroller General as the officer who can create, under the Government Annuities Act, life annuities in the name of any person they deem fit. Any person they deem fit is every person who is registered with a birth certificate. Immediately upon registration, the notification goes to the registrar. The registrar notifies the designated Crown Officer, and the designated Crown Officer will notify someone in the National Debt Commissioner's office. Then the Comptroller General will facilitate the paperwork that creates a life annuity in the name of that child. A life annuity is a perpetual, it's an instrument that is a perpetual generator of credit. It is no debt. If you've got an annuity that starts out with a value of £1 million, it has an interest payment which is paid either quarterly or annually, depending on the type of annuity. Let's say it's annually at 10% interest. So it's at £1 million, and over the course of a year, it will gain 10% in value. And the next year, it carries on, and so on, and so on. So every single year, it gains that amount in value, the interest, it gains in value. So, this annuity is sitting there, or the dividend for this annuity sits in an account, waiting to be claimed by the guardians of the beneficiary. That's the child. But because these facts were never disclosed to the parents, and because they don't generally look on the statute law databases, they had no knowledge that this annuity was created. And after 7 years of lying unclaimed in that account, under the Sestakv Act 1666, which is with regard to property that would seem to have been abandoned for the benefit of the reduction of the national debt, as per the terms of the Government Annuities Act 1929, the Comptroller General claims that beneficial interest for the Crown and puts it in the consolidated fund, which is really their war chest. That's why we refuse to register the birth of our child, in the main. In addition, there are a few other things, and I think it's best expressed by reading the declaration that we sent in response to notice requiring a qualified informant to give information for the registration of birth. I'll read a bit of that just so we can get into the mood. To my wife, at the address, on the date, Under Section 2 of the Births and Deaths Registration Act 1953, the duty is placed on you to give information to me of the particulars required to be registered concerning the above birth within 42 days of the date of that birth. It appears that you have failed to discharge this statutory requirement. Now, therefore, in pursuance of the above Act, I hereby give you notice and require you to attend personally the Register Office, Civic Centre, Newcastle, on the date, to give information to the best of your knowledge and belief of the particulars required to be registered concerning the birth and to sign the register. I shall be in attendance at the place appointed on the following days at the following times. List of dates when the registrar is available for the meeting. If you fail to comply with this requisition, you will be liable for prosecution. And just the bollocks on the bottom, reiterating the same. It's a punishable offence to disobey this statute, etc., etc. So that's what prompted the conversation, and this is what we said. Declaration of denial of consent to register children, strictly private and confidential. We, the authorised representatives for the legal persons, my name and my wife's name, do hereby declare that the following is a verified plain statement of the facts as we perceive them. Let it be known by all concerned, interested and affected parties that 1. We have been granted irrevocable superior guardianship rights over our children by the Creator of the universe. 2. We have accepted irrevocable power of attorney over our children's well-being and property until the 18th anniversary of their birth. 3. 4. On behalf of our children, we have settled their entire legal estate into a private trust which is administered for their maximum benefit. 4. The property settled into said private trust includes without limitation any and all information pertaining to the existence of our children, strictly precluding the disclosure of the details of their birth to any party whatsoever. 5. Any and all disclosures of information pertaining to the existence of our children would represent a breach of the aforementioned private trust, and all those parties responsible for said breaches will be liable for charges of £30,000 sterling or functional currency of the United Kingdom per occurrence. 6. We do not recognise or consent to any perceived obligation, whether statutory or otherwise, to register the births of our children under any circumstances whatsoever. 7. As trustees of the aforementioned private trust, we affirm jointly and without division that we refuse to grant our consent and or authorisation of the registrar or any other individual, organisation or legal entity to register information pertaining to the birth of our children under any circumstances whatsoever. Then it's just the declaration and both of our autographs and the seal. So, now, what would you imagine happened after we sent that? Well, should I put you out of your misery and read you what they sent in response to that? There's no title on it, but it should be called, "Now look here!" Dear Mrs. Title she doesn't recognise. I have written to you on a number of occasions regarding the registration of the birth of your daughter. Well, that's 30 grand for a start. She was born on the 11th of June 2010 at the place of birth. Well, there's another 30 grand. I have no alternative but to report your failure to register the birth to the Registrar General. That's the Chief Registrar of the entire Crown jurisdiction here. I have been instructed by him to send you a further requisition which is duly enclosed. They sent a repeat of the one I just read you. I note the responses from me, however, and I must emphasise that in accordance with the law, the primary responsibility for the registration of birth lies with the mother of the child, and failure to do so will lead to prosecution. Threatening my wife, trying to get to her, trying to say, well, no, he's going to get you into trouble. Please contact this office immediately with a view to making a convenient appointment. The telephone number is blah blah blah. I urge you to respond in a positive manner to this request, as your daughter will face considerable difficulties in the future if she does not have a birth certificate. I look forward to seeing you in the near future. Signed by the registration officer. So, I wrote well, I was ready with a conditional acceptance. And the terms of this conditional acceptance would basically prove that we weren't granted the things that we were granted, that we acknowledge in the declaration that I just read you, prove that there's a benefit in registering for our daughter, and prove that we have consented to the statutory authority that you claim over us. And of course they couldn't do it. They couldn't do it. Now, I also pointed out to them that in the unlikely event that we were found guilty of giving them the information that they are requisitioning from us, they would be liable for the charges that had already been levied. But if we were found guilty by a competent court, we would be more than happy to pay the fine of £2 per occurrence. They didn't write back after that. But I did get a correspondence from the passport office when we contacted the passport office with a view to getting our daughter a passport. Because you see that there's a lot of misunderstanding of a supposed invisible contract that exists when you make an application for a passport. There isn't. There is a very express contract in existence. This contract involves the recognised sovereign in any jurisdiction who has monopolised control of the borders is obliged under international law, since there is not one international border where you do not have to have some form of photographic identification across. The Queen, upon application through her agent, has to issue a passport, which is, in law, a security agreement on loan to you from the Queen. Have a look on the passport and you'll see who it belongs to. Must be returned to Her Majesty the Queen if she so desires. The reason for that is this passport is a security pass for you to cross those borders, and it's a guarantee to the people, to the authorities over those borders, that should you break their law and they want to deport you, the Queen will pick up the cost, and then you'll get your passport revoked probably, and the liability to you. But that's all it means. So, even though my daughter, no encumbrances whatsoever with the state, because we didn't register her, passport office getting a little bit shirty. This has never happened to them before. A little bit flummoxed. Don't know what to do. No regulation, sir. No regulation to follow here. So, this is what they sent. And again, it's to my wife. Passport application. Thank you for your recent passport application. Unfortunately, I'm unable to process this request due to the following errors. You have not supplied a full birth or full adoption certificate or equivalent documentation. To enable your application to be processed, please provide a full birth or adoption certificate or equivalent. Equivalent. Please refer to the document table in the information guidance that was enclosed in your information pack for further details. Please send original documents only, as photocopied documents are not acceptable. And then just a bit about the law and how it's very recently changed. But I can tell you that in that guidance it said some form of declaration other than the parents, other than by the parents, from someone who has first-hand knowledge of the facts or has been informed by someone with first-hand knowledge of the facts is quite sufficient, even though there's no regulations for that. This is for those circumstances in which someone who they want to grant citizenship to, for some reason, quickly, doesn't have a birth certificate handy. So they got to prove it through a stat deck from someone with first-hand knowledge of the facts that they are a citizen or were born at a certain time, etc., etc. So, we went to a doctor, or rather, hang on, it actually gets a little bit comical here. We were going to go to the doctor and ask him to write a letter saying, this has taken place at the birth, at this time, at this place. I've been informed by the midwife or the surgeon, whichever he was informed by, because the surgery was writing to us, wanting us to write to register with the surgery. And then the doctor, our family doctor, never done this before, turns up with our allocated health worker at the front door without sending a letter, looking like they were having nervous breakdowns at the very thought of having to come and do this. And I took them in, and they didn't want a cup of tea or coffee, and I said, well, I take it this is because of the lack of registration. And they went, yes, yes. Well, we've just never known anyone to do it before. We're a little bit confused as to why you do it. Would you mind explaining? And I explained everything that I've explained to you. And their jaws hit the floor. But at the end of the conversation, they said, well, to be honest with you, we've come and we've seen you with your daughter, and both of us, and they, we were more than happy to have her weighed, because we didn't have some proper scales to wear. So they saw when she was naked on the scales that There was no damage being done to her. She was very, very happy. That was their common law duty, to make sure that a child hadn't been born into an abusive situation, or that they were endangered. That was their common law duty, which they then expressed would have to be adhered to over the first 2 years to establish that there was a pattern here, that the development was good or was impaired for whatever reason. It's a common law duty, not a statutory one. They also accepted they had no right to force us if we didn't consent to that, because she wasn't registered. Okay. So they were very happy to go away and tell their bosses what happened, but they still got sent back after 6 months. But when they came back after 6 months, they were completely chilled out about it, went through the same process, had a bit of a laugh, asked them if anyone else had done the same thing. They said, no, we don't think it'll be happening again. Well, right, so anyway, so that's the background to all of that. And I said to the doctor, I rang him up after this, and I rang him up and I said to his receptionist, can I speak to Dr. Coffey, please? And she put him on after a prolonged pause, which I assume was because he was with a patient, but I think they were having a conversation. Oh my God, they're on the phone, what do they want? And he came out and went, yes, can I help you? And I said, yes, would you be prepared to write a letter confirming that the birth of our daughter took place? Yada yada. Yes, no problem, big sigh of relief. I had the letter within 2 or 3 days. No problem at all. Sent that to the passport office. And the passport office wrote back and said, oh wait, yes, I have not, they hadn't received what we'd sent when they sent this. I have not received a reply to my letter of 25th of August about your passport application. Please let me know if you want to continue with the application. If so, please send the outstanding documents or information by this date. We will hold any documents and fees until we hear from you, because we'd already paid. If you want to withdraw this application, please send us a signed letter confirming this. However, should you choose to withdraw your application, you will lose your money, and any new application will be subject once more to the full fee. Will you please write to us referencing the number on this letter? We did exactly that with the document from the doctor, along with the application which they already had. Within 10 days, we had a passport for our daughter. And she has no encumbrances whatsoever. She's already travelled across the border. We were in Schiphol Airport, and we were supposed to be flying back to Newcastle from Amsterdam. And they've got, I don't know if you've seen, they've got body scanners for all flights from Schiphol to the UK. And everyone who was flying back to Newcastle Airport, Geordies who aren't renowned for being polite, was standing watching everyone getting fried in the radiation, and seemed to be quite looking forward to it. And we got to the front, and I said to the customs guy, no, we're not going through there. You'll have to provide us with an alternative. And he said, really? What's that? And I said, because we don't believe there's been enough research done to prove categorically, beyond any doubt, that we're not going to be doing damage to our health and our daughters, so we're not going through. And he went, all right. And he walked over and got his boss. His boss came over, asked us the same question. She got the same reply. And she said, okay then, we'll just open the other gate. And we went over, and there was like a tape. So everyone in the queue stood gawping, Geordies as well, stood gawping as we went through the old scan. No problem. Staff didn't give us it didn't even give us a filthy look. They were more than happy to be accommodating in that situation. And we thought this would start an exodus, you know. Everyone had heard what we said. Well, they were in a queue, so they thought they'd stay there. They all got radiated. We shouldn't keep standing in the queue, you know. We shouldn't.
Can I just ask, your daughter's passport, what type is on it?
Say again?
What type of passport is the letter after the type?
After the type, what do you mean?
On your passport, it's got your picture, it's got type. The rest of us have got type P. Which I understand means cousin. What's your daughter got on her passport?
I'll have to check. I don't care what it means, because she's a sovereign, you know. So.
Yeah, I'm interested to see if they've got something different there.
It might be, yes, that's very interesting. I'll take a look.
Thanks,
Okay, so that's the first aspect of my dealings with the Crown in that year. What preceded that, I believe, was my dalliance with Her Majesty's revenue collectors. Well, I moved from London to Amsterdam in 2003. I was away for a couple of years. Then I was in Spain, and I was here for a bit and moved to Spain, and then I came back, and I resettled here to rebuild the life that I had deconstructed at first subconsciously, but following that it was most definitely conscious. And I got to a point, again, much along the same lines as why we made the declaration with regard to our daughter. I decided that I wasn't going to pay a penny in tax or late filing penalties, and I wasn't going to give any tax returns when I returned to the UK under any circumstances, and I was going to see how long it took for them to find me. Well, they found me, and they sent me demands for a couple of years, which I initially ignored, and then I wrote to them explaining that I didn't believe that I had a liability, that they couldn't prove that I had one, and I made a declaration, it was called Declaration of Cancellation of Tax Registration. And in this declaration, and all of this is on Free the Planet, I declared that there was no evidence that proved beyond reasonable doubt that I could be deemed a taxpayer. The reason for this is, from a certain point in time before that, I declared my sole mission on this planet to be the founding of the Universal Community of Self-Realization, or UCT, for the benefit of mankind. And I declared this to the Queen. Therefore, no one could suggest that I didn't have a legitimate mission that hadn't already been recognised, even though it was through the Queen's acquiescence. She could have objected, and she didn't. Because of this, I said that I could not be deemed a taxpayer because I'm receiving no income of any kind. Because everything I do, I give away to mankind for free. Anything I receive is a gift or a donation, and it's purely voluntary. No income of any kind. I will no longer seek to create a profit, because that necessarily creates a loss. And then I asked them to prove beyond reasonable doubt that they weren't spending a penny, or they hadn't spent a penny of any of the money that they'd received in taxes from me previously in any of the illegal wars against in Iraq or Afghanistan. And I asked them to prove that I had received any benefit from any money that I'd given them in the past for so-called public services, to prove that it was spent on those services that I actually benefited from. And they couldn't do it. They got very angry. Okay, so this is from 8th of February 2010. Okay. Overdue self-assessment return. We are sure you appreciate the link between individuals paying their taxes promptly and the allocation of money to public services that we all benefit from. That is why you must send in all overdue returns and payments immediately, since you do not appear to have done so. If you do not, we will have the legal right to estimate the amount that you owe, and this could well be more than you need to pay if you send in the overdue returns. The estimate is legally enforceable and could lead to the seizure and or sale of your goods at a public auction, or it could mean you're being taken to court or made bankrupt. Act quickly. If you have misplaced your returns, you can print duplicates from the HMRC website. Alternatively, you can phone the above number if you have no access to the internet. You will need to do so immediately and post the returns, etc., etc. Okay. So I sent them an opportunity to cure their dishonour of the condition of acceptance that I already told you about, because they failed to provide the evidence that I was a taxpayer. And then they sent this one. Further to my colleague, Mrs. Langdon's letter to you of the 18th of March, I write now in response to your letter of the 9th of March. Initially, I would advise you that both the presumption and time deadlines stated in the penultimate paragraph of your letter are not accepted, as I will explain. I am sure that you are as keen as I am to bring this matter to a swift conclusion. With this in mind, I will answer the points in your letter which are relevant to the matter in hand. This is the head of the Debt Management Office, by the way. You have been sent self-assessment tax returns for the years shown at the head of this letter because you are registered with HM Revenue and Customs, not anymore, as a self-employed person. I can see that you have filled in self-assessment returns in the past For example, for the years 2001 to 2, 2002 to 3, and 2003 to 4, in which you have completed a self-employment page describing your trade as variously, etc., etc. There is no indication on any of these returns that you have ceased self-employment, and this is why you correctly continue to be issued with returns. Because you have not completed or filed these returns, you have been charged penalties upon which interest continues to accrue. Furthermore, when a taxpayer fails to meet his obligation to file a return, HMRC has the power to raise a revenue determination to estimate the liability due and unpaid. This determination is recoverable in law and can only be superseded by filing the return. There is no right of appeal against a revenue determination. And there's the list of things. The legislative basis upon which these actions are based can be found at the following points in the Tax Management Act 1970, Section 28C, Section 93.2, Section 93.4. There is no requirement in legislation for HMRC to provide the material evidence requested in your letter, and this vitiates the presumption in the penultimate paragraph of your letter. If this is still unclear, you may wish to seek advice from a qualified legal professional. You should now complete these returns, yada yada yada. Okay, so I just sent them a reminder, and I then received something a little bit unexpected. After the reminder that they just sidestepped all of the issues, and that they couldn't prove that I was a taxpayer, and that they couldn't prove that I'd had a benefit from anything I'd paid, and that they couldn't prove that anything I'd paid hadn't been spent on the illegal wars, I got sent from a different office the tax return for that year. So I sent it back. Refused for cause. That means at a 45-degree angle, in red, I printed on, because I got a template made on my computer, block capitals, red ink, refused for cause, without dishonour, without recourse, without prejudice, on the front, and I sent it straight back to them. I didn't hear anything back for a month. And then I got this. This is from a different office again. We have looked at your last tax return and do not propose to send you any more returns in the future. However, if there have been any changes in your financial circumstances since the information given in that return, they mean my declaration, or they change in the future, you must let us know straight away. That's pretty much it. The rest is just blabber. Nothing. Meaningless. In other words, they accepted that I was no longer liable for tax. I just proved that tax is voluntary. You have to volunteer to be a taxpayer. They presume that you are until you rebut it, or it's well and truly rebutted. Because that didn't come on its own. That came with another letter from a different office. Because you see, in the declaration I denied, when I cancelled the tax registration account, in the letter I denied HMRC the right to create any more negotiable instruments in my name. You know the tax return, who in this room has received a tax return? Right. Did it have on the bottom something that looks like a cheque with 2 payees?
Yeah.
That is a cheque with 2 payees. That is a negotiable instrument that has the same value as a cheque once duly executed and filled in with a value. We think that that is just a payment slip. If we fill it in and send it back with the payment, they think we want to pay twice, and they accept them both. If we try and use that as the payment, they tell us that we haven't sent the payment. That's called fraud. But most of the people within the system don't know it's fraud. They don't believe you when you tell them that's a negotiable instrument. But I will tell you that I have first-hand knowledge, with all of the documentary evidence proving that it actually happened, that hundreds of people, through a guy called Doug, who was a friend of mine, have been paying with those remittance slips Canadian revenue bills for the best part of the last 2 years, and I've seen the proof. So they're accepted in Canada, which has a law system based upon this law system, but nevertheless, I'm not aware of anyone who's achieved that here, and yet I know many who've tried. I did get this when I cancelled the account. Thank you for your recent claim to repayment. I didn't make any claim to repayment. I cancelled the account. A payable order in the form of a money order for $178.64 is attached. This includes repayment supplement arising and already present at $78.64. If you have any queries, please contact this office according to the above reference. That was a rebate of the credit that stood in the account at the time I cancelled the account, which had to be returned to me. I didn't know it was there, but that's what they sent. So, have I had anything from HMRC since then? No, not in relation to self-assessment. Nothing. Absolutely nothing. Have I had anything from any tax department? Only one. 2 mistakes from the contributions agency, who clearly hadn't been informed about that situation. I haven't received anything now in about 9 months from them. So I think they've realised what their clerical error was. Because again, there's a fee of 30,000 for sending me an invalid claim, or for creating an instrument in any of my names and using it illegally for their own gain. Okay, so what we have here is, that's it, you take everything that I'm saying at face value, is we have prima facie evidence that you can volunteer to be non-taxable, but it means you're going to have to exist in their system, or find a new one to join, or create a new one to join, or be part of a new one, in order to stop being a taxpayer. Because I understand it's very difficult for everybody just to say, all right, I'm going to give up all forms of income and just survive on donations. You might not even know what you want to do yet. Therefore, that's why we set up the UCT in the way that we have. Anybody who wants to be a beneficiary of the UCT just has to consent. Anybody who wants to become a beneficiary in an official sense needs to create a private family trust. If they don't have other family members, it can just be a private trust. This trust would also be known as a living trust. If it's a family trust, the parents grant all of the property and anything else they want to include for the benefit of their children, even if they're not born yet. If you don't have any children, you have no intention of any children, you can grant it to other parties. Because any trust just has to have the right parties within it to stand as a trust. They are. The grantor of a trust has to be the one granting the property. The trustees, who can also be the grantor or grantors, can't be the sole beneficiaries. There have to be other beneficiaries, otherwise the trust will collapse. So what I'm saying is, you as parents, even if you don't have a partner or another parent to have children with yet, you can still create this kind of trust for the future, and you can amend it as you see fit. We've got a template to create these private family trusts on freetheplanet.net in the Universal Community Trust section. As I say, you can find pretty much everything there. Now, what happens if you do decide that it's possible for you to extinguish your responsibilities in the other system? Let's just say it was feasible for you to do that, and you created the family trust. That means none of your property is taxable anymore. That means you will not pay any inheritance tax. That means you will not pay, and your children will not pay, any capital gains tax. If you create a family trust to become a beneficiary of the UCT, you will also be within the jurisdiction of the UCT. And when there are enough beneficiaries within your local community, you will get everything within the community for free, and you will give away whatever it is comprises your sweat equity, which is what dwells in your heart at all times for the benefit of everybody, so that we can all live together in harmony, knowing that we were all born with an unalienable right to live on this beautiful, bountiful planet in harmony with it and the universe and with everybody else. We've come through the darkest part of what is known as the grand cycle of the precession of the equinoxes. Who knows what that is? Would you like to say?
The precession of the equinoxes
Yes.
is every 26,000 or 25,000 years.
24, yes, but a lot of
And
people
we
say
just come
26.
to the end of that. If your timeline is correct that you said before.
Well, it's let's just say that if the darkest part of the Dark Ages will be the time when the light in the form of knowledge and wisdom and divinity and unconditional love an eternal knowledge like violence only ever begets more violence, and that to love unconditionally everybody and everything is the only way mankind was intended to live. And when mankind does live that way, all of these problems that we think are inevitably caused by the so-called negative traits of mankind that we're supposed to accept about ourselves, that we're told and programmed we can do nothing about, all of it we can do something about, because we are creating it all. We are creating everything around us at all times. And until we realize the power of our thoughts and the power of our energy, we cannot stop the chaos around us. But once we start living with only love in our hearts, even for those who appear as our enemies, suddenly we have no enemies anymore. We only have brothers and sisters. Now I can say, because you can imagine, let's just say I've taken on every single state agency and every single corporate entity that was claiming fraudulent debts from me, and now, at this stage, 3 years later, and it's been like this for a good long while, I have no outstanding claims against me. Not one. They all know where I live. They all know what I'm doing. None of them are trying to stop me. None of them are making a claim against me. And that can only be in my heart. I know it to be true because I am doing this. It's what I'm supposed, not just being here tonight, being in a lot of other places, expressing what I'm expressing to you. The mission to found the universal trust. This isn't my idea. All I'm doing is recycling the divine knowledge that is being channeled through me, through the ether. All of this, everything, this group of people here tonight, this is not something that could be dismissed as just a coincidence. You're all attracted here by the energy for your own unique reasons. And what I'm here to tell you is, we are right on the brink of being able to offer to every beneficiary of the trust the means to create their own credit to extinguish their life of debt slavery. We're right on the brink. And we should know within the next few weeks whether or not this is going to be possible to wheel out right across the planet. At the same time, the sovereign nation where this bank resides has indicated through an intermediary that they're interested in signing a treaty that we've been developing called the Declaration of Unalienable Rights. And this declaration takes in what we've discovered as the ancient rights, freedoms and customs of the ancient Britons. Now, when I tell you that there are certain aspects of this which are so unfathomable almost when you are first confronted with the information, that it's very, very difficult to revert back to default setting and to be cynical about all of this and think, well, you know, maybe this is just some utopian ideal, maybe this is an idea that sounds good in practice but it wouldn't work, there are so many reasons why it won't work. And what I would say to you, if you're having that kind of response, is you might be right. And I'm not going to dismiss the fact that you feel that or take that position. What I am going to say, that in my experience, if that means anything, is that to be a cynic, it doesn't take the knowledge of how to do anything, including how to be a cynic. It's very easy to dismiss things because of the programs we've all been affected by. And what I'm saying to you is, everything that you're saying, being presented through me tonight, is 180 degrees different from what I could have presented to you 3 years ago, because I hadn't rid myself of the fear that was still lurking in my subconscious. I hadn't yet been able to reach the point where I was able to cognitively absorb enough information to present some kind of picture that people could sit for 2 or 3 hours on a Wednesday night in the Northwest and listen to. The reason I've been through these processes was to establish whether or not the system was accommodating for anybody that tried to live their life in freedom and peace without creating any harm, injury or loss. I wanted to see what it would be like if I tried to live that way in their system. I only came up against opposition. They didn't stop me doing what I wanted to do, or my family, A lot of other people who I know, who I've helped, and a lot of other people who I've met through doing these things have had similar experiences, but by and large, people are just receiving injustice from the court system. And by the same token, from the public institutions, so-called public institutions, the NHS, despite the wonderful people that work within it, the staff are no longer being trained how to, if they ever were, how to cure people of ailments. They're being trained how to prescribe drugs for everything. I know so many people over a certain age who are scared of going into hospital, and I'm not saying, I have direct experience of family members being saved by the brilliance of health professionals. So don't think that I'm dismissing health professionals, I'm not. I'm saying the training is not to cure, it's to treat. To treat does not make better, it continues, it perpetuates. My mother has been on various forms of pharmaceuticals for 25 years. She has no ailment that could not be cured by a natural remedy, and every ailment that she is suffering from has been caused by the pharmaceuticals, because that which she was aiming to cure is no longer an issue. That went a long time ago. Blood pressure related issues, they went. Now it's osteoporosis. Now it's brittle bones. Now it's not being able to sleep, being constantly constipated, all caused by the pharmaceuticals. I'll give you an example. This is something that absolutely freaked my parents out, even if they're in their 60s, both of them, and it absolutely freaked them out, despite what they know about my life to date. I broke my ankle. I completely knackered it. This is last year. It was cracked on this side and on this side. I couldn't walk. I couldn't put any weight on it for 4 weeks, and then I couldn't walk properly for the best part of 3 months. And then I started training on it, and I've been walking without people knowing for about the 4-month stage. And I didn't go to hospital, not even for an X-ray. It was at 4 o'clock in the morning when it happened, and I didn't want to put my family through that. So we went home, and with the support and love of my wife, Amma, very understanding, not yet 2-year-old daughter, they got me through the first night's pain, and we applied oregano oil. This is organic Mediterranean oregano oil for the swelling. It took the swelling down, and every 3 hours I had to reapply it, and it was blowing up like a football, and it was going back down to half a football. And this continued for a few weeks. Eventually, when the swelling started to go down, and by this point my parents are committed to the idea and telling everyone that I really have lost it this time, because I refuse to go to the hospital, I'm never going to walk again. And, you know, a lot of people believe them, because I'm getting phone calls saying, why did you go to the hospital again? And I explained that I didn't want to go into the hospital because I believed that I could treat it and heal it myself. And when the swelling had died down, I started applying organic comfrey ointment. The ancient British name for comfrey ointment, or rather comfrey, knit bone. In the book, what can I say? No X-ray, nothing. No crack, both cracks gone within 4 weeks of starting to apply the comfrey ointment. Now, the ligaments, which were also shattered, are still regaining strength, but I haven't had any pain for months now. And as I say, it's full recovery. Full recovery. And that's just using comfrey ointment, following the oregano oil. I can also tell you that here I have a mole that you might be able to see, but I used to have one just next to it. And that mole that was just next to it disappeared and left a little bit of crater that I won't invite you to feel, but you can feel a little bit of a crater. And I put oregano oil on that. Oregano oil from the Mediterranean has an ingredient in it, the active ingredient. It has to have at least 80% caravel in there. And if it does, it is the strongest antiseptic known to man or woman. The strongest. It's so strong that in its pure form, when you put it on something that could be malignant, like a cancerous growth, because I developed what seemed to me, because I have looked into what might constitute melanomas, it seemed to me to be a melanoma, and I didn't want to go to the hospital. I thought I'll just put, if it's anything, the oregano oil might get rid of it. And wouldn't you know it, 3 days disappeared, completely disappeared. And I've used this to treat other moles that seem to be getting crispy, you know, because I've been in the sun or because I've used too much suntan lotion. I can tell you, having lived on the Mediterranean for a short while, the skin problems I had were while I was using suntan lotion. I got burned. When I stopped, I didn't get burned anymore. I didn't sit in the sun all day either and get sunstroke, but I didn't get burned anymore. So just to let you know, and these I think were the consequence of me sitting in the sun with suntan lotion on. But they went with that oil. Now I can also tell you that childhood eczema that I suffered from every winter on the backs of me calves was cured with Miracle Mineral Supplement. That's Jim Humble's cure. I can't remember it's called sodium chloride, or it used to be. It's been developed. He's got MMS2 out now. The first one was MMS1. Again, you can go to the health section at Free the Planet and see information on this. There have been lots of scare campaigns put out in the mainstream media about this, but there are a lot of accounts on the internet from people who claim to have cured everything from types of cancer to eczema, common colds. For me, you can take it orally, or you can apply it on your skin. I took it orally to get rid of the eczema, and it got rid of it in a couple of weeks, but I only took it 3 times because I couldn't stand the smell of the taste. And lots of people can't. It makes me gag. That's why I looked for an alternative, and I found it in the oils that I was talking about. However, the one oil that isn't so, or wasn't so readily available, and the best of the lot, to my knowledge, is hemp oil. Hemp oil, and the work of Rick Simpson, the wonderful work of Rick Simpson, who made a film called Run From the Cure, a Canadian guy. He grew a shitload of hemp on his land in Canada, and he told the authorities why he was doing it. He was doing it so he could provide hemp oil for the people he knew in his family and his friends who were suffering from cancer, and he cured them. He cured them when they were days away from death. You know, and the testimony of the former cancer victims is in the film, and he's been given the world. He doesn't want any adulation, he doesn't want any claim, he doesn't want any money. He wants everyone to have the medicine. Well, if anybody is suffering from any major life-threatening disease or anything else, or just wants to promote their own well-being, there is a website called hempforvictory.com, and you can be provided with the medicine if you get in contact with them. And these are DVDs and leaflets all about it, and until they're gone, everyone can take one at the end. So I'll pass those out. Now, I haven't tried that yet, but I know people who have. And that we've been programmed to believe about the NHS that it promotes health. It isn't true. It's supposed to. The hearts of the staff in the main are in the right place, because it's a very difficult place to go to if you're interested in making money. Because even the doctors, you know, they only make money in the private sector, which is of course where a lot of the best treatment is available, but it's still treatment. Not most of this stuff that we're talking about, the European Union have already or are attempting to make illegal. And of course, hemp oil is illegal. But that means that there's legislation saying that hemp oil, or prescribing that hemp oil, is illegal. Well, I can tell you one thing that is never illegal or unlawful under any law made by man. And that is the unalienable right of men and women and children of legal age, which is covered in the first two, I must admit. But men and women cannot be prevented from medicating themselves under any circumstances with whatever they deem fit and appropriate. It's an unalienable right. If you want to medicate yourself with Domestos, no one can stop you. If you want to medicate with hemp oil, no one can stop you. But they're trying to. Because what would happen if all of these natural remedies were known by everyone, were taught to everyone? No pharmaceutical industry anymore. We don't need it. There are things like anesthetic in serious situations where we need surgery that maybe, yes, we do need. There are certain painkillers like morphine under certain circumstances that could be used in very, very dramatic situations. I'm not saying we should get rid of all of it. What I'm saying to you is the vast majority of people who are using pharmaceuticals prescribed by the medical professions are suffering as a result. Their health is getting worse, not better. when all of the natural remedies to cure virtually everything are available now to all of us. It's just we haven't yet become cognizant of the knowledge. The wonderful thing is, just knowledge of a few of these things can get rid of virtually every problem. Who has heard in this room of tissue salts? Okay. Guy at the back. What do you know about tissue salts?
The homeopathic or now ones in the no form of treatment or cure.
For what?
Any illness you want, basically.
Exactly, exactly. Now, this is going to sound like a little bit of a non sequitur, but bear with me. I found out through growing my own garden, very, very, very early days, but enjoying it. I cut up half the garden and dug it up and put 65 vegetables in it, so it all went wrong, obviously. But anyway, I realised that one of the problems with the soil is it's got a shortage of potassium and magnesium. And I did some research and found out that the shortage of potassium and magnesium is not because of anything I did to it, because I haven't used any chemicals on it. Because of who previously used chemicals. And it was a lawn before. It's because of the chemicals used to grow the grass or put on the lawn. It's suffering from a deficiency, so I've got to add those substances and other substances which I'm not yet aware of or I don't know enough about to tell you about. But when I thought about that, I thought, hang on a second. So chemicals in the land, they create a deficiency of nutrients that the soil needs. Well, what if chemicals in the body create the same deficiency? They do. All our chemical intakes have created a deficiency in the natural tissue salts that we need to be healthy. It produces unnatural aging, it produces joint problems, arthritis, rheumatism, osteoporosis, etc., etc., etc. The research I only found because my wife is after having 18 months without it, after a very difficult 6-month period, suffering from carpal tunnel syndrome, after she gave birth and when she started breastfeeding. She got it very, very badly again a few weeks ago, and we decided that we would have another look for the cause, which we hadn't been able to find previously, and then just I did a search on the internet. First search I do in this PDF from a renowned international homeopathist, if that's the right, a homeopathic doctor and researcher. He put it out there, and it's exactly what you said. Anything you like, different types of tissue salts in a tablet form. It's really cheap. You can get it even on Amazon, but there are other dedicated websites. You can get it organic, no chemicals in them, just tissue salts. The testimonials I've read are, this is not just something that works for carpal tunnel, this gets rid of it, along with many other things. And there are different tissue salts for different ailments, as the guy was saying. So there you go.
You'd be subject to surgery. No.
Say again?
You'd be subject to surgery.
Surgery, yes. Surgery
which creates more money.
Which creates more money. Yes, exactly. That's very painful to go through, even though most people, if not all, say it works. Okay. So let's bear all these things in mind. That's health. What about education? How many of us in this room have not been through the public schooling system? Were you educated?
Well, in this country we call public school a school. It's only in America where the public school is what we regard as normal.
What I mean is, did you go to school?
A normal school.
A normal school. Well, that would be the public schooling system rather than schooling. That's what I mean. They're fooling the public by sending them to schools, which are really they are part-time concentration camps for children, so that adults can be taxpayers, both adults. To rip the family apart, to take mothers and fathers from their children as early as possible, and to program the children when they're most vulnerable and most receptive with a multitude of programs. They're all about repeating what you're told, doing what you're told, obeying the rules, otherwise there'll be shit to pay. Yeah, and that's what they're there for. They're not there to educate, they're there to program. The reason that this is provable is because if that was not the case, everyone in this room would have been given a classical education. A classical education involves 2 strands. The trivium, which is grammar, logic and rhetoric, And the quadrivium, which is the study of numbers, maths, the study of numbers in space, sacred geometry, the study of numbers in time, music, and the study of numbers in time and space, astrology. Yes, astrology. And if you are educated with a classic education, if you have that, you are able to become, by the age of 7 years old, an autodidact or an autodidactic learner. That means you can teach yourself anything. You just need to process the information and observe and then apply. That's it. It must be in the, if you're talking about the trivium, grammar, logic and rhetoric in that order. The grammar is the information, the words. The logic is putting them into a semblance of order to communicate certain points. And the rhetoric is the way in which it is expressed in that conveyance. Okay. What I'm telling you here is just telling children not to ask questions is a perversion of education. And that happens in every single classroom. Because the teachers are put under so much pressure to pump out this curriculum, which is really programming, and there isn't any room for anything else. There isn't any time for anything else. And then, of course, during a certain period of time, when the economy was a little different, lucrative or relatively lucrative pay deals and incentives such as not being able to get sacked without doing something really bad were offered to the teaching professions in order to attract people who weren't really interested in teaching. So now you have, up and down the country, classrooms full of people who admittedly, openly are there because of the holidays. And they might have been there for the pay at one point, but they're not now because it's not so good. And again, I'm not saying that there aren't many people who are there for the right reasons, because there are, but generally, if you're working in a state school, you spend a lot of time banging your head against a wall. When I was at state school in the 70s and 80s, it was nowhere near as bad as it is now. But it was still bad enough for me not to want to be there most of the time. What I'm telling you is that in my experience, having done the research, children who are home educated, not only is it a myth that they suffer socially because they don't go to school. Everyone who goes to school wants to know the kid who doesn't. They want to know how they get away with it. So as long as the parents are prepared to organise events, social events, and make sure that they don't cut their children off home education, provided that you have at least one parent who's able to duck out of the system, is the most viable option. However, how many people in this room would say that that is a viable option for them at the moment? One.
I'm open to be doing it.
That's brilliant. That's brilliant. The other thing
I
about
can see the martial law coming into the school. I'm watching it very, very, very closely, and I can see common purpose in there. So
there's no doubt.
Got to get them out.
Yeah, there's no doubt. There's no doubt. And
my cousin who has 11 children schools them at home.
That's wonderful. That is wonderful.
The only thing they have a problem of speaking. They don't have the pronunciation is not really good.
Because they're not naturally English speaking.
No, it's not that. They live in Russia.
Oh, they live in Russia.
Yes,
So
and they have problems because, although I do agree with you what you're saying. Simply, I was taught as a teacher, and children do need to pronounce properly so the others could understand and everything.
Yes.
There's, certain issues. And the point is, although my cousin is terribly intelligent guy, he doesn't know these issues. And that's why the children are speaking as this. They understand each other.
Yeah.
But if people from outside have problems.
Well, that would be something that they can work on, though. That's
But the point is, the parents not always have the ability to teach.
But this is why we need to community. Yes, when we have, because our aim is to have home education and natural therapies, or home education network available to all the communities within the UCT, but also natural remedies. But the home education network is because people like my wife, maybe someone like yourself, would love to do it right. They'd love to be in an environment that is right for the kids. Because, believe it or not, all of the evidence on classical learning suggests that the best educated children are the ones who lead the education themselves. Whatever they gravitate towards, that's what they find out about. That's what they learn about. And this is the way, to be honest with you, when you look back, this is the way all the so-called geniuses of bygone ages were trained. They were given a classical education. All of the genius composers, etc., etc., they were hothoused like this. They were taught the basics, grammar, logic and rhetoric and the quadrivium, and then said, what do you want to do? Well, I want to play this instrument until I've conquered that, then I want to do that. And they were allowed to do it. Telling children that they have to do what everybody else has to do, and that's just the way it is not acceptable. And that's what all the children are being told. It's what all the adults are being told. And it isn't the case. Now, what we need to be ready to do is to say to ourselves in every moment of our lives that until we stop doing what we know in our hearts is wrong, the chaos will continue. The day we decide to take every moment and do with it what we think is right, we can be wrong, but then we learn from our mistakes and become stronger and wiser because of it. I never learned anything from any of the successes that I've had. None. Nothing. I already knew what was confirmed to be right before the success. I learned everything from the errors that I made, or by observing the mistakes that other people had made when I didn't have the time to make them myself, or by helping other people when I didn't know what the remedy was. The day you decide you're just going to do the best you can in every moment will be the day your life and your existence, it starts moving in the direction that you want it to. When you let go of the fear and you just say, right, whatever it is today that needs to be done, I'm going to do it. And no one's going to stop me doing it. Everything will change. Everything will crystallize. Okay, so let's just say that the House of Rothschild, which controls not only the banking industry, not only every single multinational trade platform over $2 billion, every company that's ever projected earnings or turnover over $2 billion ever has had to be rubber stamped by the Bank of International Settlements, which is a Rothschild bank in Basel, Switzerland. Every single one. There are rumours coming out of researchers like Ben Fulford that this is just in the process of being stopped, that the trade platforms, they've been suspended, and that may well be why hundreds, if not thousands, of bankers worldwide are either resigning, getting sacked, seconded, or getting arrested and charged with fraud. The CEOs in the main, did not know jack shit about what was going on, and yet the people who did, they're not being charged. They're not being sacked. The allegations aren't even being made against them because there are so few people who actually understand the way the banking system works. Anyone who does knows a central bank in any system guarantees enslavement to debt. Full stop. Anyone who's done the research into central banking knows there hasn't been a central bank in existence that wasn't controlled by one or all of the triumvirate of power. The Vatican, the Crown, and the House of Rothschild. That's it. They've been in cahoots since the late... They've had a pact since the late 18th century. Sorry, the late 18th century. In the 1770s, and we only know this, get this right, there was a messenger on a postal horse who was struck by lightning and killed. And somebody found a sealed message from Adam Weishaupt, who'd been appointed as the head of the Illuminati it was a consortium of, I think it was 9 or 11 people who had been appointed by Amschel Rothschild in secret to be the kind of guardians of the Illuminati and to appoint the people to run the infrastructure, and Adam Weishaupt was chosen to front it. The reason why this was so significant is because Adam Weishaupt was from the Society of Jesus. He was a Jesuit priest. He did the deal for the Jesuits, who were really in control of the Vatican and still are. So from that point, at that point, Rothschild already had control of all of the crown heads of Europe. And he did this simply by funding both sides of every war, causing every revolution, controlling both sides with the control of the flow of information. And this culminated when Nathan Rothschild he gained knowledge that the Battle of Waterloo had been won by Napoleon, the knowledge of the victory, and he went to the London Stock Exchange and stood in his usual place, and everyone knew that he was likely to get the news first, and he went in with a face like thunder, and his expression was downcast. Without any further ado, sell everything! Sell your mother if she's available, because everything's gone to shit. He'd already put people on the floor in secret to buy everything up when it was at its lowest price, which he did, by which he took control of the entire East India Company, which became the Crown. Not only the East India Company, every other commercial enterprise of the so-called British Empire he took control of. Because he also took control of the crown heads of Europe, because he had them in hock. All of them were in hock. So he did the same to the Vatican and the Holy Roman Empire, until all of the Holy Roman states were at war with each other, and none of them had any money left. So what did Rothschild do? He calls in the Jesuits in the Vatican, and he calls in the crown heads of Europe, and he said, look, I'll forgive you debts if we form this pact to control everything with this long-term plan, which is going to take centuries to bring up. It's all there. Eyewitness testimony, first-hand accounts of all of this is available. Putting it all together in one place. I must thank you very, very much for making this such an enjoyable occasion. I hope you've enjoyed it just a fraction as much as I have. I've still got energy to talk for a bit yet, but nevertheless, I know everyone's got lives that they've got to get on with, and thank you very much. I hope